Welcome to the Compliance Counsel on Command webinar series. The topic today is the CFPB's Loan Originator Qualification Rules. I'm Jeff Anderson, an attorney at the Dickinson Law, focusing on regulatory compliance for community banks. The CFPB Loan Originator Rules in 1026.36 contain provisions on both compensation for loan originators and qualifications for loan originators. I cover the compensation provisions in another session in this webinar series, and today I'll focus on qualifications. The threshold issues with both the compensation and qualification rules is the definition of a loan originator. Who is a loan originator under these rules? I cover that in greater detail in the first 5 minutes of the compensation session. So if you want to get more detail about that definition of who is and who is not a loan originator, where that line is drawn within your staff, I encourage you to listen to the first 5 minutes of that compensation session. For purposes of today's presentation, keep in mind that the CFPB rule definition of loan originator is much broader than the SAFE Act definition. Under the SAFE Act, MLOs have to take an application and offer, and extend, or negotiate the credit. Under the CFPB rule, it's take an application or offer, extend, or negotiate the credit. That's a bit much broader. So all of your SAFE Act MLOs will be loan originators under the CFPB rule. But you may have employees who are not registered MLOs who will fall under the CFPB loan originator rule and be subject to both the compensation and qualification requirements. Quick refresher on the SAFE Act. The SAFE Act requires loan originators employed at the bank to be registered with the NMLS, the National Mortgage Licensing System. So there's a website out there. They have to register. Consumers have access to that website and can enter the unique identifier number of a loan originator and find out information on their history. You have to annually renew your loan originators, and under the SAFE Act, there's no training or real detailed qualification requirements because there's really two SAFE Acts out there. One that requires licensure. That one does not apply to bank employees. And then the second reg is registration. That's the SAFE Act that all of your loan originators are under. You're only required to register. You provide information and you keep your registration active, and you're compliant with the SAFE Act. The licensure section for state licensed non-bank employee loan originators, they have to go through training. They have to do training to get their license and then annual training to keep it up. So keep that in mind. That'll come into play later when I talk about the training. But SAFE Act right now isn't changing with these new rules. It's just these qualification rules overlay to some extent on top of them. So this is the language from the regulation. So let me read it to you, and then we'll break down the pieces and talk about what it really means. It says, for each loan originator employee hired on or after January 1st, 2014, or who was hired before but not subject to regulatory background standards and not required to be state licensed, you must get a criminal background check, a credit check, and, as applicable, information from the NMLS about any administrative or civil findings. So what does this mean? This really breaks up the universe of employees that you have into a few buckets. You have, for each loan originator employee hired on or after January 1st of 2014. There's your first. That's anybody who you hire who's going to engage in loan origination activity after January 1st of 2014. If you hire them after that date, then you have to get these background checks, and these qualification rules I'll discuss are going to apply to them. Okay, so there's one. Your second class is or those who were hired before but who are not subject to regulatory background standards and not required to be state licensed. What that really means for you, that's your current SAFE Act MLOs. They were hired before January 1st, 2014, but they were subject to a regulatory background standard. So you don't have to run your MLOs who are registered under the SAFE Act that you hired prior to January 1st through these background checks again. You already did it once. That language is given a carve-out for those currently employed prior to January 1st SAFE Act MLOs. So that leaves you with your third bucket, your third classification. You're going to have potentially some employees who were hired prior to January 1st, 2014, but who are not SAFE Act MLOs. They were not subject to regulatory background standards, but they are loan originators under this new broader definition. Those employees, you'll have to run through these new checks, this new background check requirement, before they engage in loan origination activities going forward. So again, to summarize, SAFE Act MLOs and any other loan originators who are hired after January 1st, they're all subject to these new qualification standards. Then when you get to employees hired prior to January, it depends on whether they're a SAFE Act MLO or not. If they are a SAFE Act MLO and went through those background checks for that, you don't have to run them through this again. You just can't have any knowledge to the contrary that they would be disqualified. So you don't have to run these checks again. Your employees hired prior to January 1st who are not SAFE Act MLOs but who are loan originators, then you're going to have to run through this again. This is all very confusing because of these two definitions of loan originators we have out there. You have the SAFE Act definition and this Reg Z definition, and there's a lot of overlap. So this can get a little bit confusing. So what does that mean? Let's back up. You have to get a criminal background check, a credit report, and information from the NMLS about any administrative or civil findings. What do you have to do with that? What's the application of that? Well, there are only two real bright line disqualifications under the rule. You can't have any loan originators who have a felony within the last 7 years or who have a felony involving dishonesty at any time. Dishonesty would be money laundering, something involving the financial system or financial dishonesty that's a felony. Those are going to be bright line disqualifications. These absolutely can't be loan originators. Then what you do with those background checks, the criminal and the credit and the NMLS check, it's really punted to you, up to your own subjective hiring standards. The commentary to the regulation gives you a little bit of guidance, but all it really says is you just have to have some procedures in place where you're assured that your loan originator has demonstrated the financial responsibility, character, and fitness to warrant the determination that they can engage in loan origination activities honestly, fairly, and efficiently. There's no other bright lines with that. So there's nothing that says you can't hire somebody who has a bankruptcy within the last 5 years, or who has, a certain amount of dings on their credit report, or who got busted with marijuana possession in college. All of that, outside of those two felony bright lines, everything else is up to your own policies and procedures, your own hiring standards. So whatever you're comfortable with as far as financial responsibility and character, that can be your hiring standards. Now that's not to say that an examiner couldn't come in and question your hiring standards, particularly if you have any problems arising with your loan originators. Of course they still can, you all know that, but there's no other clear directives in the regulation. Just the two felonies, and then you have to have some policies and procedures in place. The commentaries even explicitly state that you can rely on the absence of negative information in their criminal and credit report to make this determination. And you might look at this language and say, well, how am I supposed to determine whether somebody has financial responsibility and character? I give them an essay test, I follow them around for a week, how do I make that determination? You can rely on the absence of items in their criminal and credit checks to make that determination. What about after hire? So you have these qualifications and checks you have to do at the time of hire before they engage in loan origination activity. After they're hired, however, you don't have any duty to continue to monitor those qualifications. You don't need to run these checks annually. It's a one-time, at the time of hire requirement. After that, you just can't have any knowledge to the contrary that they meet their qualification requirements. So you don't have any duty to monitor it, but if you get notification that Susie Q, the loan originator, just got a felony arrest, now you know about it and they're going to be disqualified. You don't have to go out and check it, but once you know about it, they're going to be potentially disqualified if they don't meet your hiring standards. But before I move on to training, with those hiring standards, it's very subjective and it can vary from bank to bank what a particular bank is comfortable with their hiring standards. And some might give a little bit more leeway with some dings on the credit or bankruptcies than others. So what I really encourage you to do is just, have it reviewed by some professional, your legal counsel, or even somebody within your bank that has some expertise, be it compliance or legal, just to get an outside viewpoint of what those hiring standards are and get another, perhaps some other thoughts and contributions. And also, most importantly, whatever your hiring standards are, be sure you apply them consistently. If you're not applying them consistently, then what's the point of even having them? I mean, at that point, it's just window dressing for the examiners, which does have some value, we all know, but you should really be applying those consistently after you adopt them and, really minimizing any exceptions to that hiring standard to the greatest extent possible. In addition to the qualification standard, there's a new training requirement under the CFPB loan originator rule. So remember when I was discussing the SAFE Act, we talked about the difference between licensure under the SAFE Act and registration, and that currently bank employees are generally registered, and there's no training requirement under the registration portion of the SAFE Act. Well, now there's a training requirement under the Reg Z CFPB loan originator rule. But they don't tell you exactly how much you need. What it says is you need to ensure that your loan originators get training that's sufficient in frequency, timing, duration, and content to ensure they have the knowledge of the laws that they need to engage in their loan origination activities. So you have to take into consideration what your loan originator's job responsibilities are and tailor the training to meet those responsibilities. That's really all they give you. The only thing they give you in addition to that is this safe harbor. So it says in the commentary, if your loan originator gets 8 hours of NMLS certified training, that'd be the training that licensed MLOs under the SAFE Act are required to get annually. It's an 8-hour requirement. If they get that every year, that will meet this rule. So it's a safe harbor, but it's not a requirement. They tell you what the higher hurdle is to clear, but they don't give you very much guidance on how low you can go to still clear that hurdle. So what you're left with is some decisions about how much training do you give your loan originators. And it really depends on your bank and depends on your risk assessment. The safest approach would be to just get all of your loan originators NMLS certified training, 8 hours. Then there's not going to be any question that you're complying with the rule. But that could be expensive, and it could also be overtraining some of your loan originators. And I'm not saying that's not the right solution for some of you. It may be, but you may have loan originators at your bank who they're not registered SAFE Act MLOs. All they're really doing is one small piece of loan origination activity. For example, you might have some customer service representatives that all they do in the loan origination universe is just help borrowers fill out applications. That's all they do. So they may not need that full 8 hours of training given their job duties. If they get it, they get the safe harbor. But you may be able to give them a lesser amount of training. They may need training particularly on fair lending issues and things like that. but they may not need all the detailed training that your really full-time loan originators would require. So some banks go, a step below the NMLS certification and maybe get 8 hours of NMLS certified training or just 8 hours of non-certified training, but that's structured in a way similar to NMLS certification for their, for lack of a better term, real hardcore loan originators, those loan originators who that's the majority of their job function. But then for those loan originators who only have a small piece of loan originator duties, they tailor it to fit their needs. So maybe it's 2 or 3 hours focused on fair lending, if that's really where their activities lie. Other banks, you may just say, we don't really have a lot of NMLS certified options in our area, and we can give the training internally or get it done efficiently externally, and we're comfortable with not taking advantage of that safe harbor. And that's a perfectly fine decision. The safe harbor is just that. It's just a safe harbor. It's the least risky avenue. But that doesn't mean that you're taking on undue risk by having a training plan that doesn't get NMLS certified training. If you develop a training plan that is targeted to your loan originators and gives them the training that they need, generally on an annual basis, I think you'll be safe under this rule. Particularly if for those loan originators you have that are the hardcore loan originators, if you look at that NMLS agenda, and if you structure training based off of that, and then if you document that training well, and the rationale for the training that different loan originators are getting at your bank, I think you're going to be set up pretty well for compliance with this training rule. And, the fact of the matter is right now, there's just not a lot of NMLS certified trainings out there. Right? There will be. I mean, this new rule is going to trigger a lot more entities to become NMLS certified. But prior to January, most bank employees weren't required to get certified training. So there weren't that many entities out there offering it. So many banks, therefore, are really looking at other training opportunities that they can get outside of that NMLS certification. Last thing on training, well, last two things. One, it applies regardless of when they're hired. So whether they're a SAFE Act MLO or not, or hired before or after January 1st, doesn't matter. This training is going to be required. It's also, it says periodic, but given that most other trainings at your bank are done annually, I think you want to do this training annually as well, unless you can really document a justification for doing it less frequently. Also, the rule says that it can be delivered through webinar or any other interactive means. To me, that language interactive means that it has to be live, that it can't just be an archived, recorded training. I think there's some room to argue with me on that. You may be able to have an archived training where there's still an interactive component, or there's the chance to still interact with the presenter after the fact, and perhaps that qualifies. But conservatively, I think other interactive means, to me, indicates that the CFPB wants it to be a live interactive training, whether it's in person or done electronically. Last two changes that I'll talk about with the loan originator rule, unique identifier and record keeping. Under the SAFE Act, all loan originators got this NMLS number, unique identifier, that they're required to give with the first written communication with a borrower and on request. Now this Reg Z rule adds to that and says you need to also provide that number on the credit application, the note or loan contract, and the security instrument. You need to provide the name and NMLS number of both the bank and the individual loan originator for that loan on all of those documents. If you have more than one loan originator, you list the one who has primary responsibility, and you can really define who that loan originator is. and just apply it consistently. There's nothing in the regs that defines who has primary responsibility. If you have loan originators that leave your bank or change positions after those docs are issued, you don't need to reissue them. It's not a changed circumstance that requires reissuance of documents. You can just leave it on there. You just need to have them on there at the outset. Another thing to note on this, there's 3 documents right now, the credit app, the note, and the security instrument. There's a placeholder there that's left blank, and I would assume that that placeholder is going to be filled by the new TILA-RESPA early disclosure rules, that will be added here. So look out for that down the road. Record keeping requirement is a little different for these loan originator rules than it is for other areas of Regulation Z. Your general retention requirement is 2 years under Reg Z. For loan originator rule compliance, it's going to be 3 years. What you're going to be retaining is evidence of your compliance with the rule. So compensation agreements, evidence of your actual compensation, policies and procedures, those types of items. And hiring, the hiring standards that you used, etc. Lastly, this is a rule that explicitly requires policies and procedures. Examiners require policies and procedures on more of an ad hoc basis in many areas, in many instances, but this is one that you can bet that they're going to look at the policies and procedures because the regulation explicitly requires them. So make sure you have written policies and procedures that address all of the loan originator areas. Dual compensation, compensation based on the term of a transaction, steering, loan originator qualifications, and use of the NMLS ID number. This first round of examinations you'll get after these loan originator rules have come out, I really expect them to take a pretty close look at policies and procedures. And that's really the threshold issue. And it's very easy. I mean, these rules are new for examiners too. And it's easier to look at policies than it is to really dive down into the weeds and look at files. So I really encourage you to get those policies cleaned up before the examiners come in. Have them reviewed, double check them, make sure you have everything addressed in there so you have less things for them to point out. Those are going to be the easy things on their checklist that they can point out as a finding on your examination. That concludes this session. Thank you for listening, and I hope you can tune into some more. Again, I encourage you to also listen to that loan originator compensation webinar I have in this series. Thank you.